Okay, I'm in Chapter 3 of Criminal Procedure, Arrest and Search Persons, and that's the section title that I'm entering right now. The Supreme Court has long expressed... Okay, Arrest, Search, and Seizure is the chapter title. The section is Arrest and Search of Persons. The Supreme Court has long expressed a strong preference for the use of arrest warrants and search warrants. As the court has indicated in a host of cases, resort to the warrant process is preferred because it introduces an orderly procedure involving judicial impartiality, whereby a neutral and detached magistrate can make informed and deliberate determinations on the issue of probable cause. To leave such decisions to the police would allow hurried actions by those engaging in the often anti-competitive enterprise of ferreting out crime. Yet, as the cases in this section and the two following, dealing respectively with search of premises and search of vehicles, clearly demonstrate there are a great many exceptions to the warrant requirement. When the court approves warrantless activity, it is typically because of the view that the police are acting in exigent circumstances, where intruding upon Fourth Amendment interests or third, were otherwise not involved in activity as to which before the fact judicial scrutiny would be useful. The first case in the section, U.S. v. Watson, explains why it is that no warrant is required to make an arrest. The next case, U.S. v. Robinson, addresses warrantless search of the person's incident to arrest. Robinson gave rise to two significant issues later addressed in the next two sections, Wren v. United States and Atwater v. City of Lago Vista, respectively, whether an arrest or other Fourth Amendment seizure made on probable cause may nonetheless be unreasonable because the officer's ulterior motives or his departure from usual practice, for example, as set out in police regulations, and whether an arrest on probable cause may nonetheless be unreasonable because releasing the offender on a citation would have sufficed. Maryland v. King concerns whether taking and analyzing a cheek swab of the arrestee's DNA is a permissible aspect of police booking procedure. The final case in this section, Birchfield v. North Dakota, considers whether blood and breath testing to determine intoxication qualify as searches incident to arrest, and if not, whether they are properly mandated by implied consent. United States v. Watson. Justice White delivered the opinion of the court. Reliable informant Corey told a federal postal inspector that Watson had supplied him with a stolen credit card and has agreed to furnish additional cards at their next meeting, scheduled for a few days later. At that meeting, which occurred in a restaurant, Corey signaled the inspector that Watson had the cards, at which point the inspector arrested Watson without a warrant, and he was authorized to do as he was authorized to do under 18 U.S.C. 3061 and applicable postal regulation. The Court of Appeals held the arrest unconstitutional because the investigator had failed to secure an arrest warrant although he conceivably had time to do so, and this was a significant factor in the court's additional holding at Watson's consent to a search of his car was not voluntary. Section 3061 represents judgment by Congress that it is not unreasonable under the Fourth Amendment for postal inspectors to arrest without a warrant, provided they have probable cause to do so. This was not an isolated or quixotic judgment of the legislative branch. Other federal enforcement officers have been expressly authorized by statute for many years to make felony arrests on probable cause, but without a warrant. Because there is a strong presumption of constitutionality due to an act of Congress, especially when it turns on what is reasonable. Obviously, the court should be reluctant to decide a search thus authorized by Congress was unreasonable and that the act therefore unconstitutional. Moreover, there is nothing in the court's prior cases indicating that under the Fourth Amendment, a warrant is required to make a valid arrest for a felony. Indeed, the relevant prior decisions are uniformly to the contrary. Just last term, while recognizing the maximum protection of individual rights could be assured by requiring a magistrate's review of the factual justification prior to any arrest, we stated that such a requirement would constitute an intolerable handicap for legitimate law enforcement and noted that the court has never invalidated an arrest supported by a probable cause solely because the officers failed to secure a warrant. Gerstein v. Pugh, 1995. And the footnotes include what looks like the entire case. The case is construing the Fourth Amendment, thus reflect the ancient common law rule that a peace officer was permitted to arrest without a warrant for a misdemeanor or felony committed in his presence, as well as for a felony not committed in his presence if there was reasonable grounds for making the arrest. This has also been the prevailing rule under state constitutions and statutes. Because the common law rule authorizing arrest without a warrant generally prevailed in the states, it is important for present purposes to note that in 1792 Congress invested United States Marshals and their deputies with the same powers in executing laws in the United States as sheriffs and their deputies in the several states have by law in executing the laws of their respective states. The Second Congress thus saw no inconsistency between the Fourth Amendment and giving United States Marshals the same power as local peace officers to arrest for a felony without a warrant. The balance struck by the common law in generally authorizing felony arrest on probable cause but without a warrant has survived substantially intact. It appears in almost all of the U.S. in the form of express statutory authorization. This is the rule Congress has long directed its principal law enforcement officers to follow. Congress has plainly decided against conditioning warrantless arrest power on proof of exigent circumstances. Law enforcement officers may find it wise to seek arrest warrants where practicable to do so, and their judgments about probable cause may be more readily accepted where backed by a warrant issued by a magistrate. But we decline to transform this judicial preference into a constitutional rule when the judgment of the nation and Congress has for so long been to authorize warrantless public arrest on probable cause rather than to encumber criminal prosecutions with endless litigation with respect to the existence of exigent circumstances, whether it was practicable to get a warrant, whether the suspect was about to flee, and the like. So Stevens did not take part in the decision. Powell concurred. And that'll be the 4 pages that I'm not going to include in this recording.